I have the pleasure of being the director of our Howard Intellectual Property Program. We chose that as the specific title because it gives us a really cool acronym. Howard Intellectual Property Program is HIP. Put a lot of thought into these things. I'm also the director of the Institute for Intellectual Property and Social Justice, which is an independent NGO and member of an accredited member of the World Intellectual Property Organization. And so we enjoy a great relationship with them as well. For those of you who were here early and on time, you didn't get the opportunity to get one of our glossy celebrating 15 years of intellectual property and social justice CLE brochure. And so we're just going to pass that out, and there's a number of them out there on the table. Because we are running a little bit behind, I'm going to forgo the usual additional historical remarks, et cetera, et cetera. But what I do want to do is to introduce our two program chairs. And as you can see, as you rise very, very high up in the hierarchy here, you still have to hand out brochures. So our program co-chairs, our copyright, trademark, right of publicity program co-chair is Tasha Bunch, standing over there. In the, she is a graduate of Howard Law School, and is it okay to mention your other title? Yes. She is also the newly appointed, I guess you start, what, Monday? Or maybe you've already started. She is the Chief of Staff for the Commissioner of Trademarks at the United States Patent and Trademark Office. And for those of you who have been with us for the entire 15 years, or in and out of those 15 years, we have with us our founding co-chair of this program 15 years ago. That's the difference between Esther and I. Esther still looks exactly the same. I have lost a thing or two since that time, so I don't need my Afro pick anymore. Esther Lim is a partner at the Finnegan Henderson firm, and you were running one of their little small offices where again? Yeah. So you can either thank her or blame her. Just depends upon what your IP perspective is. So Esther will be chairing the bulk of the morning program, and of course what will happen is that we have our two tracks in the afternoon. Just a quick administrative announcement. You will have signed in there, whether you're getting CLE credit or not. Everybody has to sign in. Some states have required that. If you have any questions, the volunteers outside will be happy to answer anything you need. Subsequently, after the program, when we receive the credit codes, those of you who have been with us before know that what will happen is that you will get an email from us, and you will use that code, and then you will get your CLE credit from whatever jurisdictions you signed up for. This morning, the entire program will be here. At lunchtime, we are going to walk over to the luncheon venue where we'll have a nice lunch and we'll have two sessions. And then for the afternoon, the copyright trademark track will continue over in that room. And then for the patent track, we will bring everybody back here. And then folks doing the copyright trademark track will rejoin you here for the last hour of the program, which is our last plenary session, and that's our ethics session. So, without further ado, I will turn the program over to somebody who really knows what she's doing, Esther Lim from Finnegan Henderson.
Good morning, everyone. Wind's blowing, trees are down, snowflakes flooring, but we're all here. So thank you for being here and being early. Happy 15th anniversary to the conference, and hearty congratulations to Professor Mtima for his vision, for his hard work and dedication in growing HIP and the conference over the years. It's been a delight and a pleasure to work with Professor Mtima, Tasha, and the wonderful team here at Howard, which includes the students. I know we're running a little bit behind, and so what we'll do is for the first panel, we will extend it to 10 a.m. and the judicial panel will start right at 10 a.m. and move forward. I'm so delighted to present to you the first two speakers, the opening presentation, Chip Ratu and Tom Irving from my law firm Finnegan. They have been the opening act for this conference. I think, Tom, you've been here since the very beginning. So he's been here for 15 years, and Chip joined soon thereafter. And I know that many of you, familiar faces here, know about Tom and Chip. And as soon as you hear them, you'll know why they're the opening act here. So without further ado, Chip Ratu.
Thank you, Esther. All right, well, welcome everyone. Thanks for bearing the winds. So I'm going to go, I apologize because I'm going to go quickly, but I'm originally from New Jersey, so I can talk fast. So that shouldn't be a problem. So I'm going to talk about the big cases this year, and later on there's going to be some programs about the Tam case and the Brunetti case, which dealt with the constitutionality of Section 2A of the Lanham Act. I'm not going to spend a lot of time on them because we've got afternoon programs on them, but I thought it would be good to at least set them up, tell you what happened, so that when we hit those cases later on, we can just jump into the real analysis. The first case, many of you know, it's a Supreme Court case, Tam. And in this case, it was a rock band from the West Coast, and they registered for the mark, or applied for the mark, slants. That was refused as disparaging to Asian Americans because slants is a derogatory term. But the band was trying to reclaim the term, and their thought was, look, we are an Asian band, Asian Americans, we are going to make this term, this disparaging term, non-offensive. Ultimately, the Federal Circuit, after some yo-yoing, decided en banc that that Section 2A is unconstitutional, at least as it relates to disparagement. Case went to the Supreme Court, and we're going to talk about this at the lunch panel, and it's really weird and interesting, the decision. A lot of people disagree with it, but in essence, Justice Alito held that Section 2A is viewpoint discriminatory. And what's interesting is the issue of whether this is a viewpoint neutral or discriminatory provision came down to the fact that it essentially is happy talk. He said, yes, it doesn't discriminate against any one group, but it discriminates against negativity. And what he said, and I thought this was very interesting, I love this part of the opinion, he said, the proudest boast of our free speech jurisprudence is that we protect the freedom to express the thought that we hate. And my kids sure agree with that. The ability to express hateful thoughts is a viewpoint, and that viewpoint was discriminated against, according to Justice Alito. He also talked about whether this was government speech, because if it is government speech, then it can't be regulated the way you could commercial and other speech. And the court found it is private speech, not government speech, because, and it was interesting, the court said, if you look at this, otherwise the government would be babbling inconsistently. That if you look at all the trademark registrations out there and say that the government is giving those messages, is endorsing those messages. The government is not saying just do it when they register Nike's just do it. The government doesn't care. They're just registering these marks. So it's not government speech. The message of these registrations is not something the government is condoning or expressing themselves. And then interestingly, this is where it gets into kind of some interesting constitutional issues. The court said regardless of the level of scrutiny, and they kind of punted on that. What kind of scrutiny do we have to give the analysis of whether a section of the Lanham Act is constitutional? They said, no matter what it is, the government fails. There were some concurring opinions. Justice Kennedy said that we can look at what kind of scrutiny this is, and because there is viewpoint discrimination, that it has to be heightened scrutiny. And so 4 justices signed on to that: Justice Ginsburg, Sotomayor, Kagan, and Kennedy. And then there was a concurring opinion, Justice Thomas, who says strict scrutiny will apply to content or based discrimination regardless of whether the speech is commercial. So you have, everybody agreed with the result, but it is kind of a mess, and we'll talk about that later. The unanswered question really is, when you look at it and you check the boxes of where the justices fell, what level of scrutiny would apply to a content discriminatory but viewpoint neutral clause in the Lanham Act? And what is that? Well, that is the scandalous and immoral section. which takes us to our next case, Inouye Brunetti. Now, what I love about this case, this guy applied for the mark FUCT, and one of the arguments was, well, this isn't scandalous or immoral. The F word is FUCK. This is FUCT. And as you can imagine, that was knocked down because if you the board, the PTO, the Trademark Trial and Appeal Board, and the Federal Circuit all looked at actually how he used the mark, and he had things like, you're FUCT. It was like, it was clearly using the mark the way one would think. Ultimately, though, the Federal Circuit, it went to the Federal Circuit, and the government said that the scandalous and immoral clause is viewpoint neutral. It's a government subsidiary in a limited public forum, and that intermediate scrutiny should apply. That's the government. Brunetti then said, look, disparagement and scandalous, those two are similar. These should be treated the same. The disparagement section has been knocked down as unconstitutional. So too should the scandalous and immoral section. And so what happened is it went to the Federal Circuit, and our very own Judge Stoll, who will be here this morning, these are some of the questions asked during oral argument. I thought that would be interesting, because sometimes you can get some insight, even though we have the opinion already, of what was going on in the judges' minds. And I love her question. It was, what if there's a situation where a trademark is more like America is, FUCT, or the government is? And she said, why is that not viewpoint discrimination? Right? The word FUCT alone is not viewpoint discrimination, but when you add it to something else, it could be. Judge Moore had a very interesting series of questions about body parts. She said some body parts could be used in a way that offends people, others could be used medically. And so how would we examine those words? And Judge Dyke had a very interesting approach, and he went back to the Dirty Seven Words case, and his thought was maybe we should just ban the Dirty Seven Words, going back to the George Carlin FCC Supreme Court case. So ultimately, though, the Federal Circuit held that the scandalous and immoral section of Section 2A is unconstitutional. And I'm gonna go on because of our timing. So we're going to talk about those later, but that's a nice setup for those cases. There been a couple interesting cases about genericness, whether a term is generic, because if a term is generic, it is unprotectable as a trademark. And this one really hits home, because it is something we see all the time and virtually everybody uses all the time, and that's Google. And in this case, somebody registered for around 700 internet domain names. Google filed a UDRP administrative action to cancel the domain names. Google won. Then the registrant, because it's his right, appealed the case to district court and then moved to cancel Google's registration. And his argument? Google is generic because people use Google as a verb. Now, everybody, the fundamental thing about trademarks is you can't use a trademark as a noun or a verb, right? It should be Nike shoes. Not Nike. Better example probably is Xerox. You don't make a Xerox, you make a Xerox copy. Because a noun is generic and a trademark should be an adjective. Well, in this case, the plaintiff, or the appellant here, came forward with massive amounts of evidence of people using Google as a verb, generically, saying, I'm gonna Google this, let's Google that, let's Google this. And as a trademark lawyer, you look at that and you say, that's not so good, you're not supposed to do that. Ultimately, the court said, well, we're going to look at not what people are doing without digging into what they mean. And the court adopted this test, which is interesting, discriminate versus indiscriminate use. And they said, you have to look at the primary significance of the use. And here, these are indiscriminate uses of Google. It is the verb uses of these, although technically an improper trademark use, really shouldn't hurt Google because we know what people are talking about. And they said, so you don't look at what they say, you look at what they think. Because for genericness, it's the primary significance of a term. And the primary significance, the court said, is what people are thinking. And so they said, yes, they're saying, I'm going to Google this, but they're thinking of the Google search engine. So Google dodged a bullet there, as of course they should, but it really helps a lot of companies. I counsel a lot of clients who want to know when their marketing department misuses a trademark, is this disastrous? And this case now helps a lot because marketing departments typically will do what the trademark department doesn't want to do. So it's a big case. Another case, which is very interesting, is Booking.com. This is a case that went to the Trademark Trial and Appeal Board, and the issue is whether Booking.com is generic for online travel booking services. The Trademark Trial and Appeal Board said it's generic. They had to say that, because the Federal Circuit has held that if you take a generic word or a descriptive word and add .com to it, it's not protectable. There was a case, In Re Opendahl Larson, where patents.com was deemed generic. And so following the Federal Circuit precedent, TTAB said, well, Booking.com is generic. Booking.com very smartly appealed not to the Federal Circuit, but to the Eastern District of Virginia, where they could reopen the record and get a de novo review. And it went to Judge Brinkema, who is not bound by the Federal Circuit. Judge Brinkema said, I'm going to follow Fourth Circuit law. I think this is protectable. Now, Judge Brinkema is a big fan of linguistics. I've appeared before her where she loves dictionary definitions. She loves to get into that sort of stuff. And so Booking.com did a brilliant job with a linguistic expert showing that Booking.com is descriptive. It's not generic. And part of the thing is, their argument is this should be protectable because there can only be one of these. There's only one Booking.com. So you can't say that this is generic because it is truly a source identifier. Now, the court did note the level of protection is very slim, but there is protection. Another thing here to keep in mind is Booking.com won. But there is a provision, if you appeal a TTAB case, provision of the Lanham Act and also the Patent Act, if you appeal the TTAB or a PTAB case to the Eastern District of Virginia and you win, you still have to pay the government's attorney's fees. Now that is up on review to the Federal Circuit. They're reconsidering that issue. There was a 2-to-1 decision where the court held the same thing. But the question is, do you have to pay the government's fees? Judge Brinkema and so far the Federal Circuit have said yes, even if you win. So beware. Likelihood of confusion cases. This is a very interesting case. This is a case where a restaurant was going to be open called Krusty Krab. Now there's a cartoon, SpongeBob SquarePants, that has a fictional restaurant, cartoon restaurant, there it is, underwater, called the Krusty Krab. And so they, Viacom sued this restaurant. And they said, look, you can't have a Krusty Krab. This is part of our show. The restaurant said, okay, well, you can't have a trademark on something that's not real. It's a cartoon restaurant. You just can't have it. Federal court in Texas said you can. And on summary judgment they held, summary judgment, they said, even though this isn't a real restaurant, we're going to give it protection because it is a source identifier. And what I love about this is they said the services are similar. You've got a cartoon restaurant and a real restaurant. That's similar enough. So it really does open the door, though, significantly to products that are fictional products depicted in films. There have been a couple of cases about this, very few, but this one, it really does open the door to that. One of the things that was significant is Krusty Krab really has been promoted quite a bit, and you can see there, it's been licensed on Ice Pops, toys, and so it was significant that it was promoted fairly significantly. All right. Other notable cases. Now we're going to do trademark speed dating, and I'm going to just fly through a couple cases that are really important. This is a very interesting case. 20th Century Fox. There is a record company. Well, there's a TV show called Empire, and it's about a fictional record label. There's a real record label called Empire Distribution, and they sued. Now, there's this doctrine called, it's a Second Circuit case called Rogers v. Grimaldi, and it holds in expressive works like video games, films, if you use a trademark, you are allowed to use it if the mark bears some artistic relevance to the underlying work and it's not overtly deceptive. Here, that's what Fox said. They said, look, Empire is not deceptive because this is all fictional. And the record company said, well, no, because you're not using it to refer to us. You're not coming within the bounds of Rogers and the Rogers and Fred Grimaldi case. They said, and they relied upon the Rosa Parks case, where the use of Rosa Parks as the title of a song was held to be an infringement and stepping over the line because the song wasn't about Rosa Parks. Here, Empire Distribution said, this show's not about us, so how could you do this? Also, there was an interesting twist here. It wasn't just about the show, it was about the promotion of commercial items for the show. So the show was selling music and shirts and things like that. The court said that Rogers and Fred, this whole doctrine, governs not just the underlying work, but commercial promotion of the work. And Empire doesn't have to refer to Empire Distribution. It could refer to the fact that New York is referred to as the Empire State. It's broader than that. So it's a very significant case for this important jurisprudence on the trademark, I wouldn't say First Amendment, but almost fair use. Black & Decker, this case is crazy to me. $54 million verdict on a trade dress case. $54 million verdict thrown out because the survey that the expert did was so flawed. After a full trial before the jury. And what's crazy about this is, so what happened was there was a survey, and pick your survey experts right, because you've got to get, certain experts can be very sloppy and very dangerous in many respects. But what this expert did was, this involved a trade dress case involving the black and white for drills. So what the expert did was they took the plaintiffs, the DeWalt products, and put it all up on a board, replicating like a shopping situation, and then put the defendant's product, one of them, among all the plaintiff's products, which is incredibly improper. The defendant moved in limine and tried to Daubert the report. The court denied it, denied the Daubert motion, and let it go forward to trial. Then after trial, decided, you're right, this was a really bad survey, and then threw out the whole verdict. So it's incredible to me, and it's a good lesson. Don't give up. If you're going to go have to try to get an expert struck and it doesn't happen, you still have a chance after trial. All right, University of Miami. For those who do trademark prosecution, this is a very important case because it's a tricky issue that people don't always know about. And that is, the University of Miami applied for their mascot. And in actual use, the mascot's got a bunch of things that the drawing on their trademark application didn't have. They have an M on the hat, they have the word Miami, they have stripes along the side, and the PTO rejected it and said, that doesn't match. And so you're essentially trying to register more than one mark because you're registering something broader. The TTAB said, no, that a mark, the drawing can be broader than the actual mark in use. And this is really important because a lot of big brands will protect different elements of their trade dress or different elements of their mark, and now you know you don't have to have all the details in there. You can have a broader rendition of it. For example, we're working on a case with Starbucks where they're just trying to register just the green circle on a cup. And this helps us a lot because now we can say, well, we don't have to have all the other stuff in there for this to be registerable. All right, 2 more cases, and then I'm going to turn it over to Tom. Oh, let's see here. I'm sorry. And then on our final trademark speed dating, we've got this case, and I will, look at me. All right, so this case is a very interesting case because this is an trademark opposition, and the plaintiff in this case was a trademark licensee. And in order to assert priority, she had to rely upon the fact that the licensor, the company she was obtaining rights from, had priority, but she didn't. So she argued, look, and it was an individual, and so she argued, okay, I don't have priority, but I'm getting rights from this company who is the licensor, so therefore I predate the other side. And the Trademark Trial and Appeal Board said no. A licensor can assert a licensee's use, but not the other way around. So as a licensee, you can never assert rights that you're getting from a licensor. So now I will turn it over to Tom to talk about patents, and thank you for indulging my quick talking.
Great pleasure to be here. I was with Esther and Lateef 15 years ago when we did this, and it all is because I gave a talk in Ohio. And it's a very bizarre talk to the Ohio State Bar, and you do it in Cincinnati one day and then you go to Cleveland. So the way they get from place to place, they rent the IP Cruiser, and all the speakers get on the IP Cruiser where they have things to eat and things to drink. And in this particular IP Cruiser, they had a very interesting young man named Lateef Matima. And so he started talking to me about Howard and all this kind of stuff. And so I came up here and talked. And then one thing led to another. I turned it over to a competent person who'd be Esther, who then took it and ran with it for 15 years. So this is great. All I got to do is show up, shoot my mouth off for a kind of few minutes, and then I'm done for the year. It's great. So what do we think about the state of the patent law in the last 12 months? I find it very exciting. Now, I started in the field kind of about almost the same time this young man right here. I started in 1975 in the IT field when I was 5 years old. You were 15. I remember this well. And it was kind of like the professor, the dean at Duke Law School said. When I told the dean at Duke Law School I wanted to be a patent lawyer, he became outraged. He said, "This is not a trade school." I said, "Okay." And he said, "We don't teach patent law because we're not a trade school." So I came up and I went to American University. I did night school. That's how I got with Finnegan. Because I would never get a job today. I had no credentials. But at that time, I was from Duke. And they didn't have anybody from Duke. In fact, they thought it was spelled D-O-O-K. I didn't care. And the real reason I got hired, though, Doug, you need to know this, the founding partner was Mark Finnegan. And so I'm going to interview. And Finnegan looks at my resume. He walks in, he says, "Are you a Mormon?" Yeah, they don't ask questions like that. I said, "Well, yes, sir, I am." He says, "Good. You're driving the car at that." That's how I got the job. I was the best car driver for so many years. The bar hoppers, I'd sit out in the car and read cases, of course, and they'd go in and then I'd get them to the next place, and I'd get them home, and that was useful. But who would have thought back in 1975 that patent law would end up to be the big deal that it is today? Because now Duke Law School, they're all over patent law. They teach patent law. They had a 3-day seminar a couple summers ago I went and taught. I mean, they're all over it. They are now a trade school. They've become a trade school. So I guess that's good. And I thought, I didn't put it in the slides, but I thought the most interesting thing that happened in the last year was this concept of sovereign immunity. Wasn't that interesting? And I know it's on its way to the Federal Circuit now because PTAB has told the St. Regis people, "Oh, no, we're going to throw you out. You don't get sovereign immunity." And so it's going to be very interesting. My personal belief is this is far from over because not just Native Americans, there are also these things called state institutions. And I believe they have a much more solid ground for sovereign immunity than do the Native Americans. I mean, the Native Americans, we didn't even invite them to the Constitutional Convention, right? They were like, and I grew up with Native Americans, went to school with them, and we have not treated them well. Whereas on the other hand, states, I mean, I guess we're on the verge of having one less state. I'm trying to check the internet to see if California has seceded yet, but we still have quite a few states. So that's a very interesting, and I think next year there may be more to say about that than there is this year. So if you look at what's happened this year, and let's see now, I bet it's this. I bet this moves, that moves the slides. Okay, so you got the Heartland case. How many of you in the room do litigation? Okay, well, you're all over Heartland, right? Because it tells you where you can sue and whether you want to move your suit or not, and who really can go. And I understand that this has had a more deleterious effect on the Eastern District of Texas than Trump's talk about tariffs yesterday had on the stock market. I mean, whoa, that's a bad deal. And so, Eastern District of Texas, I guess people, all the hotels there will probably go out of business, the restaurants will go out of business. It's sad. But, now a lot of people, so they have these blogs that talk about all the Heartland cases and the motions to transfer, and you can, if you're interested in that kind of stuff, you can look at that and see what's going to happen. I thought this was interesting. I like charts, and this chart sort of showed, what's happening before Heartland and after Heartland. And it looks like the place where people want to go now, over and over and over again, is the District Court of Delaware, which I like. That's only a 2-hour drive away. That's you don't even have to get on an airplane. Although today I think you'd be better off on an airplane. Certainly the way I have a huge vehicle, and my vehicle, as huge as it is, was sashaying all about on the 495 this morning. I was glad to get here alive. It was a good thing. Always a good thing. Now, here's, they obviously at the Supreme Court, they get into interesting issues. They talk about, what about patent exhaustion? Now, one of the things that I've noticed, as a naturally born smart aleck and rather irreverent is, if I'm the Federal Circuit, I would have mixed views about the Supreme Court. Because I think the last 9 cases I counted up, the Supreme Court reversed the Federal Circuit 8 out of 9. Now, come on, there's something wrong here. Federal Circuit's not going to be wrong 8 out of 9 times. So I don't know what's going on there, and that may be more of a political issue than it is. But after all the things we read about in the daily news today, expecting government institutions to do the right thing may be a forlorn hope. So anyway, these cases come down, they all get reversed. Supreme Court reasons, they talk about exhaustion. The Sandoz versus Amgen. Is anybody involved in biologics and this new bizarre BLA and ABLA? That's the only reason you'd have any interest in this case. So since nobody jumps up to, yeah, I'm really interested in this, if you are interested in this, the slides are superb. But otherwise, and the slides here are also affirmed. You can kind of wait a long time before you sue people. And the thing that offends me is when you look at the reversals, it's okay to get reversed 5-4. When you get reversed 8-0 and 7-1, I would take it. I would take it personally. That's why I would never ever want to be a judge, because unless you're a Supreme Court judge, and that is impossible in my situation, so it wouldn't happen. Okay, more cases about single components, the bizarre of 271F1. What if you're shipping stuff overseas and then they assemble it and infringes the patented invention? Blah 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 blah. Well, it turns out that a single component is not substantial portion. So we know that. Is 2 a substantial portion? Heck if I know. All I know is the Supreme Court reached down and wanted to reverse this because I just think they don't like the Federal Circuit. Now, we don't have any Supreme Court judges here. We have Federal Circuit judges here, so I think anything nasty I say about the Supreme Court is all okay. Now, the main interest is, will the world as we know it end shortly? There's 2 cases before the Supreme Court. They were both argued, I think right after Thanksgiving. One is SAS, and the other is Oil States. Now, SAS, the big argument there is, okay, so if somebody files a petition and they name all these claims of the patent and they're challenging and say there's a substantial question of patentability, and yet when PTAB gets around to it, PTAB says, well, we're only going to take 5 of these claims, we'll take grounds based on 5 of these claims, and the rest of them they won't leave the trial. So then the question is, when you get to the final written decision, if you get that far, if it doesn't settle, does PTAB have to rule only on the claims that showed up in the grounds, that were so-called officially in front of them, or do they have to rule on every claim that was challenged? So the Federal Circuit said, well, you only have to rule on the claims that were actually got into the dance, got in on grounds and into the dance. Supreme Court, they grant cert. It was a Federal Circuit decision. So I apply my unsophisticated analysis and think, oh, they'll get reversed, because that's what they do. That's what they do. But there's another thing playing here. There's an SAS, but you've also, I'm so sorry, Your Honor, I didn't mean to offend you and cause you to leave the room, but,
No power at home, and the idea of coffee out there sounding so wonderful. You would never offend me, Tom.
a judge has no honor in her own home. Now we know. Okay, well, the other case that's going on at the same time is Oil States. So now Oil States really gets to the nub of it. After all these constitutional challenges to the AIA post-grant proceedings, and for years it was like, oh, this is a joke. But then they granted cert on this one, and it gets argued. And there were a gazillion amicus briefs, and everybody's going to this. Now, I'm thinking, wait a minute, the Supreme Court, the Federal Circuit, I get confused. The Federal Circuit said that these proceedings are constitutional. And then the Supreme Court granted cert? That made me nervous, because that would indicate to me, again, by my rule of thumb, that it will be reversed. But the funny thing is, what happens if they decide Oil States on June 29th, before the end of the present term, and they say these things are unconstitutional? And what do they do with SAS? I mean, a Supreme Court scholar like Mr. Magoo here, Mr. Dunner, who's also known as Mr. Magoo, he would say to you, oh, cert will be dismissed as having been improvidently granted. Even though they had all the briefs and all these arguments. So this, to me, is really interesting. People are trying to read the tea leaves, and they're trying to decide, well, did they really mean it? Did they really mean to grant SAS if they were going to find these proceedings unconstitutional? So we don't know what will happen. Certainly in my viewpoint, having been in the area since 1975, the IP area, wow, I thought that was a big deal. These AIA post-grant proceedings, because there have been like 2,000 or 3,000 IPRs. PGRs are much fewer, but that's still because the PGR is only PGR eligible if the claims have an effective filing date after March 15th of 2013. Although, believe it or not, that is receding further and further into the rearview mirror, because that was almost 5 years ago. So, and I've been in a bunch of the PGRs that have been held, but very bizarre. And, people maybe use them, maybe won't. So we will wait with bated breath. And when the oil states case comes down, the question is, whichever way it comes down, how will the stock market react? Well, we'll find out when the oil states comes down. Do I have predictions? Not that are worth anything, but I would say, no, they're not going to find it. They're not going to find it unconstitutional, because then that means they wasted all their time on the SAS case. And so, you got to have judicial economy, right? Now, I have a son-in-law who is a PTAB judge, and he was a federal circuit clerk, and now he's become a PTAB judge. I'll do anything I can to get influence, whatever it takes. And when you've got 7 children and 16 grandchildren, you can arrange a lot of marriages, get whatever influence you want. And it's all worked out really, really well. So we'll find out what happens in these cases, and they are, if I would say, eagerly awaited. So now, believe it or not, I don't know if you noticed, the month changed. We're now in March. So April, May, June. Within 3 months, we're going to know the answers. And whether we'll like the answers or won't like the answers, probably a number of law firms go out of business if they're found unconstitutional. Because a lot of people jumped in whole hog on these things and have a lot of invested in these things. Now, let me make sure. I am ending promptly at 10 o'clock. Absolutely. So let me switch over a little bit. Now, the Regeneron case. I stand before you, having been accused 8 separate times of having committed inequitable conduct. Some people call me the wizard, and some people use that in a very negative connotation. So 8 times I've been accused of inequitable conduct. Esther, you defended me. How many times have they found I committed inequitable conduct? 0! Yes, I think I'll retire tomorrow. That's true. And so I make it through. But this case, so I followed inequitable conduct cases, and every once we talk about inequitable conduct. I mean, I try not to tell people how to commit it. That's a bad idea. But how do you, and you can't avoid being charged with inequitable conduct, because no good deed goes unpunished. And so the main thing is, how do you enhance your chances so it's not found that you committed inequitable conduct? And we can go on we have books and articles and all that kind of stuff. But what is fascinating about this case is that it was one of these cases of withheld references. Now, I kind of thought, wait a minute, after the Theracents case, I sort of thought that if you're withholding references, that's usually not a problem. Because, there's so many references, and people just say, well, I didn't really know it was material, and even if I knew it was material, I didn't make a conscious decision to withhold it, and therefore there was no separate intent to deceive. And this case, too, the other interesting thing about this case, it doesn't involve a declaration. In the majority opinion, in Theracents, the court did say, wait a minute, if there's a declaration, and the declaration has false information in it, it is per se is affirmative egregious misconduct. And the way I read that, you don't even need intent to deceive, because it's affirmative egregious misconduct. There must have been something bad going on. This is not this case. So how do they find intent to deceive? Well, how many people here in the room have ever prosecuted a patent application? Okay, how many people are here because they think this is the tax law seminar? Okay, that's good. That's all good. Okay, now, we prosecutors, we've lived a tortured existence. We are looked down upon, generally, by the people that litigate. So this case is like Ferris Bueller's Day Off. This is the redemption of prosecutors. Because how do they find intent to deceive? Because of the misconduct, the litigation misconduct of the litigators. So the prosecutors say, yeah, give it to them, yeah, find it. These slimebags are getting their due, and they're the ones who committed the conduct. Well, Judge Millman, who I greatly respect, she kind of went ballistic, said, how can this be? And so now we're going to find out how this can be, and we're going to find out also how quickly I can move away from the podium because Esther's ready to go into the talk show. It has been a great pleasure being here. Thank you.